Welcome to Miller Johnson and our webinar on I-9 compliance and essential strategies. So I'd like to briefly introduce myself. My name is Ryder Koffend, and I'm with the Miller Johnson Immigration Practice Group, and I'd like to allow my colleague to introduce himself.
Great, thanks, Lee. I'm Kevin Battle. I'm also in the Immigration Practice Group, and we're looking forward to talking about I-9s today with you.
Okay, the topics that we're going to cover today briefly will include the new administration, an overview of Form I-9 common mistakes, E-Verify, we'll touch upon ICE audits, also how to conduct an internal audit, how to correct I-9 forms, and just general best practices. So we have a lot to cover, but just briefly, the overall framework. Recently, there was the executive order protecting the American people against invasion. So in the new administration, we know because of this order that there's heightened scrutiny on enforcement. The order specifically talks about enforcement priorities for removing immigrants with serious criminal convictions. But there's also concern that there could be revocation of federal funding from jurisdictions that fail to comply with federal immigration laws. And as a result of this, we're really expecting to see increased ICE presence and enforcement, specifically worksite enforcement, which could include audits or even raids on businesses when ICE is focusing on enforcement against undocumented workers. So the impact of this, could potentially be impacts on businesses. We're expecting that, there'll be increased audits. These could be unannounced, or it could be notification for I-9 compliance review. Some of the challenges that this can create if a business is going through a raid, they could potentially lose staff. This could potentially cause a work stoppage, and in some cases, they could lose employees who could be detained. So this has the potential to be very disruptive. A brief overview about I-9. Why should we care about Form I-9? Well, employers are subject to these requirements. There's hefty fines. There's also criminal penalties in addition to civil penalties potentially. Also, there can be debarment from government contracts, implications for back pay, and even having to terminate individuals where there is non-compliance. So I-9, who does this apply to? This applies to all employees who are hired after November 6th of 1986. There must be an I-9 on file. And again, this includes the whole workforce, so also US citizens. So for I-9, there's a few basic parts to this form, but just basically the form is comprised of Section 1, and that's the part that employees have to fill out anytime after the job is accepted, but it has to be done no later than the first day of employment. And it needs to capture all of this information: name, address, date of birth. There's a section for the person's status in the United States, whether they're a US citizen or other status. It has to include their work authorization, expiration date, if there is an expiration. Very important, needs to be signed and dated, and preparer or translator certification needs to be included, as well as there's a section for Social Security number, email, and phone information. Section 2 is the part that the employer completes, and the employer has to make sure that they complete Section 2 within 3 business days of employment. So the employer's role is to review the original documents by the 3rd business day and complete Section 2 for the issuing authority and the document numbers, expiration date, and when the employment actually begins. So that's an important field that is often missed. So you want to make sure that you're really watching the employment begin date. And again, there's a specific deadline to be compliant, so it's 3 business days from the date employment begins. It's possible if someone is not in possession of the required documents, but let's say there's it's being issued and there's a receipt notice, then the receipt of a document can be included with the actual being furnished within 90 days. Also, employees are not required to show the actual Social Security card for I-9 purposes unless the employer participates in E-Verify. And then finally, the document verification process requires showing either a document from List A or from List B and List C together to complete proof of identity and also work authorization. And it's very important that employers cannot specify which documents they will accept from the employee. It's just important to give them the instructions, and the employee can go through the list and decide which documents they will furnish. If you specify, even with good intentions, trying to guide an employee, oh, just give me this or send me these documents and that will work, that could be potentially construed as document type discrimination practices. So you really want to leave it up to the employee of which documents they're going to show you, and just show them the instruction list and they can select from those listed. So what is the employer certifying? Basically, the employer's role is just to make sure when they're reviewing the documents that they appear to be genuine and that they reasonably relate to the employee. The employer themselves, you're not attesting to the person's status or to their identity. You're just reviewing the documents that they appear genuine and they're applicable. And then the next section, it's actually the appendix, but the last step is really important to update or re-verify the I-9 if there's like an employee name change, or if they leave and then they're rehired, or if their work authorization expires. So the current Form I-9 version is August 1, 2023. There was the most recent release. All employers are required to use this version. And again, there's really been no substantial changes to this form version. It's changed Section 3 and it now has the appendix for the translator section, and then also for the re-verification section.
Thanks, Lee. So I want to talk a little bit about some of the most common mistakes that we see when we're looking at a client's I-9s. So from Section 1, by far the most common mistake that we see is someone forgetting to check the appropriate box. So whether someone is a U.S. citizen, a non-citizen national, lawful permanent resident, or an alien authorized to work. Sort of the cousin to that is we see individuals selecting the wrong box, so not really fully understanding the differences between the two. Oftentimes everyone knows, okay, what a U.S. citizen is, but they don't fully appreciate the difference between a lawful permanent resident, which you would typically think as a green card holder, someone who can permanently stay and work in the United States, versus an alien authorized to work, which is going to be someone who is able to work temporarily, someone who may have a student visa or an H-1B visa or TPS, that temporary status, right? And then usually when you get non-citizen nationals of the U.S., you're talking about individuals who may be citizens of a territory that is occupied by the U.S. So just really appreciating those differences. Often within Section 1, we see employees who either did not sign the I-9 or they didn't date the I-9. So those are really the most common errors that you see with Section 1. When it comes to Section 2, by and large, the most common mistake that we see is that missing certification date. So, the date in which the employee started their employment. What's that date? Oftentimes people forget to include that, or they may have missing information with regard to the employer, or oftentimes for the old Form I-9s, at the top, we'd see you're supposed to put in the employee's name and their immigration status. Again, they kind of got rid of that with the new version of the form. So that issue isn't a big issue with the new version. But if you're going back and you're looking at your I-9s for the past several years, you want to be on the lookout for that issue also with Section 2. We also wanted to talk a little bit about the use of E-Verify. And so if you are a long-term Miller Johnson client, 10, 15, 20 years ago, the advice maybe probably was, hey, E-Verify, stay away. We don't think, unless you're required to do it, we would say don't participate. Like many things over the years, I think our advice has changed on that. We think E-Verify has gotten a lot better. They have gotten more accurate. It's gotten more timely. And so to the extent that you're considering E-Verify and you had that advice previously, I would say that it's worth giving a try within your organization. So what is E-Verify? E-Verify is an internet-based system that compares the information from the employee's Form I-9 to data from DHS and Social Security Administration records to confirm that an employee, in fact, is authorized to work. And it allows the employers to confirm the employee's ability to work oftentimes as quickly as a matter of a few seconds. Sometimes there are some non-confirmations that may take some additional digging, but by and large, what we've seen with E-Verify over the past several years is that it's gotten more accurate and faster, which is encouraging for our employer clients to really utilize the system. What E-Verify is not. It's not a system that provides immigration status. It's not a pre-screening tool. It's not a safe harbor from that worksite enforcement. So to the extent that you participate, that doesn't mean that ICE or DHS isn't going to show up and want to do their own audit. It's just another tool that we have at our disposal to make sure that we're doing everything that we can to verify that an employee is authorized to work. An employer's enrollment in E-Verify is voluntary, except when it's required. So our federal contractors and subcontractors, there are oftentimes those provisions in the contracts that they must participate in E-Verify. Certain states do require participation in E-Verify. So depending on maybe where you have operations, you want to make sure that you're complying with that state's obligations. The other thing that I wanted to mention, for those of you who may have F1 students who are in that STEM field, oftentimes we can get extra OPT, so extra work authorization for those F1 students in STEM fields if you are participating in E-Verify. So the ability to get that STEM OPT extension for an additional 2 years of work authorization, you have to be participating in E-Verify in order to get that. So if you're on the fence about whether or not to join E-Verify, there's that additional benefit of being able to get 2 additional years for your STEM OPT participants. And then my last E-Verify sort of plug, they've come out with E-Verify Plus, which is sort of this new system, which is going to allow employers and their new candidates to complete sort of the I-9 and E-Verify process together at the same time. So it may be something that's attractive to you, just something to be on the lookout for. Let's talk a little bit about our DHS and ICE audits. ICE agents often issue their own subpoenas for employers' records. They have the administrative law judges who will determine the facts and whether a defendant is liable. You're not going to get that sort of full jury process that you may otherwise be accustomed to in other avenues. And so ICE kind of plays by their own rules within the administrative session or administrative setting, rather. When ICE is going to conduct an I-9 audit, they're really trying to come in and discover whether or not there is any improper documentation or whether or not an employer is following the I-9 maintenance obligations. And so they're coming in, they're looking, they're scrutinizing your I-9s, not only just the documentation of it, but also the maintenance. The audits, any information that they find can lead to further investigation into other areas and certainly significant fines and penalties. The extreme end of that is if they find knowing violations where you have corporate officers who may actively be trying to hire individuals who they know are not authorized to work, repeat offenders. They have the power to go after corporate officers, human resources representatives, supervisors, and contractors. Again, it's sort of on the rare end of the spectrum for those knowing intentional violations, but the statute does authorize that. And with our new sort of effective year, January 2025, USCIS substantially increased those fines for violations that occur both for those substantive and those technical violations. They've been raised across the board. We always like to provide some information about what those dollar amounts are so that you can really understand why this is important, right? So knowingly hired or knowingly recruited someone that you know is not authorized to work in the United States, continuing to employ those individuals after you know they're not authorized to work, that can come with some significant penalties. So, if you're a first-time offender, anywhere from that $700 range to $5,700 range. But if this is not your first run-in with ICE, those fines, they increase rapidly, and they also increase with how many violations occur within your organization. So they use a metrics or a matrix rather to determine whether or not to increase and give you the higher end or the lower end within those fine parameters. Civil fines for failing to comply with the I-9 requirements. So those paperwork violations, those can range from, $288 all the way up to $2,861. And so you really want to make sure that if you're going to be taking a look at your I-9s, that you give them the proper attention that they require. Yes, $288 may not be all that much money for one I-9, but when you start talking about real numbers, if you have thousands of employees or hundreds of employees, you start to add that up where you may be getting hit with $2,000 per violation for 1,000 people, and then you're talking about significant money. So one of the important things with I-9s is that we have the opportunity to both do them correctly on the front end, but to periodically, audit ourselves and try to make sure that we correct anything that may be incorrect. Unlawful discrimination against employment authorized individuals. There can be civil fines for that, or engaging in a pattern of practice of hiring, recruiting, or referring for a fee of unauthorized aliens. The good faith defense. So like I said previously, if we can show that we are acting in good faith, that we're trying to do it right, that we're going back and we're auditing our I-9s and we're trying to do everything correctly, we have the good faith defense that we can defend against many of these penalties by showing that the employer has acted in good faith in both the documentation process, and retaining our I-9s. So I mentioned, ICE audits, but, we want to make sure that before you get to the point where you are dealing with ICE, that you're taking advantage of that good faith defense. And how do we do that? We do that by conducting an internal audit. The one thing that I can guarantee you with both this presentation is if you conduct an I-9 audit internally, you will find errors. I know that if we conduct an I-9 audit at Miller Johnson, we're going to find errors, and we're supposed to be the experts, right? So if you conduct it, there will be errors. A lot of those things are going to be simple fixes, but if you look at your I-9s, you're going to find something that you can really correct. Our advice to you is to fix the mistakes when you can find them. Those mistakes that can be fixed, we want to make sure that we're going through and that we correct them in real time as we find them. We don't know whether ICE is going to show up tomorrow, so if you find something, let's make sure we correct it right away. The other complicated advice is let's not make things worse. So let's not backdate things. Let's not try to hide our mistakes. Let's come out and fix them, be open and transparent when they're made, and let's not make things worse for ourselves. To correct your I-9s, what should you do? So the best advice that we can give you is be consistent. You want to be consistent. Whatever it is that you decide to do, you want to do it for everyone. And that gets to that discrimination part that we mentioned in sort of those civil fines. So be consistent, apply it universal to all of the employees. You want to compare. So this is how ICE does it. If ICE was going to come in to audit you, they would say, give me a list of your payroll effective today. And they would look at all the employees on that payroll list, and they would say, okay, I want an I-9 for every single employee on this list. So if you're looking for a place to start, that's where we would recommend you start. Pull a list of your active employees from a payroll list, and let's make sure first that we have I-9s for all of those individuals. Make a chart. So I usually will say, okay, give me, a payroll Excel list, and then let's summarize, let's go through and look at the I-9s, and let's summarize all the corrections that need to be made for each I-9. And then let's go in and make sure that we make those corrections. What you shouldn't do. So you don't want to erase or use whiteout or black marker or correct tape. We want to correct things that we need to correct, but we don't want to make sure that we're trying to hide anything, right? So we're not backdating things. We want it to appear to someone who may be, auditing it, some ICE officer or DHS officer, that we realized that there was a mistake and we went back and corrected it. So what I recommend clients do is that they, whatever ink or, if they typed it, whatever they used before, that they make sure they're really clear. So, grab a red pen or some other color ink and make it clear that this is not something that we're trying to hide. We're making our corrections in this other color. We also, we notate the date in which the correction occurred. And then we either initial or we sign it, or some of our clients they'll have a memo that they attach with an I-9. So you want to really make it clear to an eventual auditor and officer that we were not trying to hide any of these corrections, but we did make a good faith effort to correct issues as we saw them.
Thank you, Kevin. That was really good insight on best practices. Also, for your best practices, you want to make sure that you have a procedure in place on your I-9 compliance. So for instance, companies can have a records retention policy. The I-9 only needs to be maintained for a certain period of time, which we'll cover next. But companies can have a policy in place where they'll keep the I-9s for the legally required amount of time, and then pursuant to their records retention, they will then destroy I-9s that are no longer legally required to be retained. Also, another best practice is Make sure you're not storing your I-9 forms with the rest of the personnel files. This can really commingle documents that don't need to be kept together, and could lead to additional review of documents that don't need to be reviewed, okay? So by keeping the I-9 separate, and when you're trying to do document retrieval just for an I-9's request, that will help facilitate that. If you have paper I-9s, there's a few best practices on how to maintain the files. So for paper I-9s, it's recommended have 3 separate files. So if you separate by category, it's going to be a lot easier if you need to pull certain records and also determine what needs to be retained and what's ready for non-retention. So one file for current employees. Why? Because they're going to need they're going to not need re-verification. If you have your current employees have a separate file, you know, I don't need to re-verify these employees. So you can have them in one compartment. The other compartment would be current employees who do need re-verification. You want to be able to identify that subset easily. Those are very ripe for mistakes because employees who have an expiring I-9, that could potentially be a compliance issue. And then the other file would be for terminated employees, because then you would be monitoring how long you need to keep those and then when those can be destroyed. So if you store I-9s electronically, you still need to make sure you have appropriate access and your system so that you can re-verify at the appropriate time. And as your I-9 retention obligations still exist, even if you have an electronic system. So for the I-9 process, you want to make sure you're providing the instructions on the I-9 form to newly hired employees. And then you also want to make sure that you have appropriate reference materials also for your company staff who will be completing the I-9 process. We really look to the best resource is the government's very own I-9 handbook for employers. That's the M274 manual. So that's a really important resource for reference. And then also have a schedule where you're performing your periodic internal audits for your I-9 compliance, and make sure you're really following the protocols that you put in place. As Kevin mentioned, when you're doing internal audit and you find mistakes and you're adding that notation, you know, you want to be transparent about that. And you can notate, for example, that this I-9 was corrected pursuant to an internal audit on such and such a date, sign and initial. To utilize that good faith defense, you know, mistakes sometimes happen, but if you make good faith efforts to correct them and you're being transparent about it and you're documenting it, then sometimes Homeland Security can be lenient and choose not to impose drastic fines. And then for the I-9 document retention timeline, so the regulations require that for each form I-9, each person that you hire has to be retained for 3 years after the date of hire, or 1 year after their employment ends, whichever is later. So it's really important to be aware that this rule is whichever time period is later. And then when an employee stops working, that's a good time where you can calculate how much longer you would need to keep their I-9. And again, by sorting your files by employees who are no longer working, you can keep a better eye on then, you know, your document retention timeline. So you can use your internal audits as an opportunity to revisit your policy, look at, you know, what problem areas are you identifying, and maybe what might you need to change, depending on what's revealed by your internal audit. Some companies find, okay, we've grown to the extent, maybe we should start utilizing software, which can be a helpful tool, especially as companies continue to grow. Even consider participating in E-Verify with the improvements and the speed that we've seen it gain over the years. Also, it's recommended if you have questions, contact your immigration lawyer rather than reaching out to Homeland Security. I do want to say that the USCIS, they do have webinars also on their own website, but it's still recommended to reach out to your attorney. If you contact Homeland Security, it could raise more questions than the ones that you pose.
Hey, Lee, I wanted to jump in with one of the questions here.
Yeah.
It was relating to sort of that retention period that you mentioned. So we got a good question. The question was, well, what's the risk for, our if we keep our I-9s beyond the retention period? So if, you have your own internal retention period, you perform on a quarterly basis or some yearly basis, what's really the risk out there if we don't purge our I-9s when we otherwise, could under the I-9 retention guidelines? And so where I think that the risks are is you never know at what point you're going to get audited by a Homeland Security, right? So if you keep I-9s beyond when you are required to keep them under the I-9 retention guidelines, the risk is someone shows up before your internal company policy and says, give me your I-9s. And now you have I-9s for employees that you're no longer legally required to keep them. And if you disclose those and there are errors on those I-9s, now you're going to get hit for penalties for those I-9s that you really didn't have an obligation to keep. So we want to try to minimize the data that we're providing if we get audited to an auditor and don't provide them with documents that we don't have to provide them with, right? And so how an I-9 audit happens is an officer shows up and you have to get all of these I-9s together in a really quick amount of time, right? And so sometimes you may be talking about tens of thousands of I-9s or hundreds of I-9s, and they may be in different places, and maybe they're off-site, or maybe that you got to get with a vendor to get everything together. And so instead of going through and saying, well, this person, we could get rid of them under the retention guidelines, and so we're not going to disclose them. What happens oftentimes is employers just provide everything, right? Okay, I'm going to provide everything that we haven't purged, and then you risk giving things that you otherwise shouldn't have provided during that period of time. So that's really the risk. Other than that, there's no real risk for it.
Excellent point. And I think that brings us to question and answers.
I'm sorry, I was just going to say, I'm sure it was the same question. You see the question that says, we should always have an I-9 on hand for all current employees and not purge any until after they terminate, correct?
So you should always have an I-9 on hand for all current employees. That part is absolutely correct. And then you shouldn't purge them until you have met this retention timeline guide. So you need to keep the I-9s for each person you hire for 3 years after the date of their hire or 1 year after the date that their employment ends, whichever is later. So you want to keep those I-9s. It isn't, hey, the person termed. It's either 3 years after the date they're hired or 1 year after the date their employment ends, whichever is later. Once you've gotten past that period of time, then you want to purge them. There's a question too about, can you clarify the retention rule? Did that answer your question? If not, can you maybe provide a little bit of additional information about what part of the retention rule you have questions on?
I see a question. Do we need to do an I-9 on people before 1986? And no, if someone was employed prior to it was November 6th, 1986, then the requirement does not apply to them.
These are really good questions. So So one of the questions is, in separating I-9s into 3 files, can you provide some examples of current employees who would require re-verification? It's a great question. So if you have an employee who is what we would term a alien authorized to work, so someone who's on an H-1B visa or maybe on a student visa, or they have temporary protected status, something like that. They may be currently working for you and they are currently employment authorized, right? But they will require re-verification. So they may have an employment authorization document, or they've got an I-94 that maybe they provided to you, and that has an expiration date on it. And so you need to make sure that you re-verify those employees. So you have employees that wouldn't require re-verification. So like, let's say you're US citizens or your permanent residents. They provide you with their documentation, they complete an I-9, you never have to re-verify them. But if you have those who are on some sort of temporary status, you're going to put those people in a separate bucket, and you have to remember that you need to re-verify them before their expiration date occurs.
So one question is asking about the re-verification process. On the Form I-9, the most recent version, they have something called the Supplement B. So it's just the very end of the form has an additional section where you can enter the re-verification process.
So good question. There's someone who asked, hey, we've had a fire, we lost some files, including some of the employee files. How would we address that with I-9? So it's a really good question. I think the answer to that is oftentimes what you do also if you have employees that are working there and you figure out I lost an I-9 or we don't have one. You want to make sure that you complete new I-9s so that if you are audited, you have an I-9 and you have gone through the process of making sure that everybody is work authorized and that their identity has been verified. So I would get new I-9s for those that you've lost or that you have identified. We don't have an I-9 for this person. And yes, those will have, different higher dates than the date that you're completing the I-9, but you got to remember that good faith defense that, hey, we lost our I-9s in a fire, or we weren't able to locate an I-9, it was lost. And so we went through the process of completing an I-9 and making sure that the employee was authorized to work. So absolutely get a new I-9.
Hey, Kevin, I see a number of questions about re-verification. Can you go through some of that?
Yes. Lee, you want to take a question and I'm going to try to read through and find some of those.
Okay.
Kevin, the question is, can you review the recertification requirements? So it's fairly broad.
Oh, okay. Yes. So I think it starts with with those individuals that we identify up front as needing to be re-verified. So our US citizens do not need to be re-verified. Our lawful permanent residents do not need to be re-verified. And then we have sort of the group of individuals who are those aliens authorized to work, who have some sort of temporary status. So the type of documents, really sort of at the outset when you're looking at the documents, you want to identify what documents were provided and what the person's status is. For those who the documents are like EADs, I-94 cards that were presented, that gives you the clue that, okay, this person is that is going to need to be re-verified. And so if you're using paper, often the paper I-9s, I would recommend that you set some sort of reminder, like calendar reminder, if you have some sort of system that can do that, or if you're using an electronic system, often, a HRS system, they usually have some sort of reminders or feature that would alert you, okay, this person's expiration date is coming up and they need to re-verify. So reaching out to those employees and saying, okay, we need to re-verify your ability to your work authorization. Here are the documents that would do that, providing them with a copy of that document list, the A, B, and C document list that's attached to the instructions. having them come in with their new documentation, and then completing, if it's someone who would be on one of the new Form I-9s, that supplement, or if it's someone who maybe was from an older version of the I-9, there's section 3, and that's where you would do that re-verification process.
Hey, Kevin, there were a number of questions about regarding lawful permanent resident cards and what to do with those and by way of expiration dates. And if you don't mind, I'll just answer all of those all together right now.
Great.
It's really important to remember that if somebody provides you a lawful permanent resident card at the time that you complete the I-9, you do not have to track the expiration date. You do not have to re-verify the I-9 after that expires. A lawful permanent resident card should be treated like somebody who gives you a driver's license and a social security card, which is we complete the form, we file it, and we never look at it again. If somebody provides you a document that shows that their employment authorization expires, for instance, an employment authorization document, then we have to track that expiration date and re-verify on or before that date. One of the specific questions on that was, well, what happens if, though, either they don't provide it or we don't ask for it before the expiration date occurs? And the answer, the short answer is, we need a valid employment authorization document at all times. And if we don't have one, and it doesn't look like we can get one, then we may be in a position to terminate employment until we can get one. But I'd encourage you to contact your legal counsel before you make any of those decisions. Sorry, that was a lot, but there were a number of questions on the same subject.
Absolutely. Thanks, Mike. Is there a special process we need to follow when purging the I-9 documents? No special process other than making sure that you are following that retention schedule. So as long as they are permitted to be purged, you can purge them under any process that you normally would use. Obviously, they may contain sensitive information on them, so you don't want to just throw them in the trash can. So, shredding them, getting rid of them, but no real special guidance there.
Here's one other one that I've seen a number of times now. What do you do when somebody shows up and presents you new documentation that has a name change and maybe a social security number change or some other indication that their identity has changed? And the answer to that can be fairly complex. The short answer is certainly we can accept the new documentation, assuming we believe that it's valid and everything is legitimate, and we can make those changes in our system and we can move forward. We can reject those documents too, and we can discipline, including discharge, if we have a policy that says we don't allow employees to provide us fraudulent documentation at the time of hire. We can certainly take that step. So it gets pretty complicated, and while many of these questions have answers, this is one that I think is worth talking over with your legal counsel.
So there's a question about an employee with a current I-9 and whether or not you're able to purge their I-9. If you have a employee who is a current employee and they were hired, before that 1986 November 1986 day, you need to have an I-9 on file for them at all times. You cannot purge their I-9 unless their employment terminates. And if their employment terminates, you're going to be looking at that retention schedule. So if they're an employee who has been hired or they've been there, the example is since 2010, your retention obligation is going to be 1 year after they terminate. So that's when you get to purge their I-9. If they're an active employee, you need to keep their I-9. Oh, here's a good question as well. What if the I-9 Section 2 document is dated after 3 business days of the start of their work? There is not a correction for that, right? If we didn't complete an I-9 timely, there's not a correction for that per se. So we want to make sure that we have an I-9 for that person that is on file. But to the extent that we didn't perform our obligation within the 3 days, there's not any magic that we're going to be able to go back and do to correct that issue.
One question is asking about re-verification if there were a marriage, and yes, there's a section supplement B for the re-verification, has a section for the name or new name.
There's a question about, we hire someone and they show us a permanent resident card and they use that. And then later they show us a social security card, but the name is slightly different. Similar but different. Which one is their legal name that needs to be on the I-9? I guess my response to that would be, if someone showed you a permanent resident card that ends and on its face it appears to be valid, I don't know why or at what point they would be showing you a social security card, but I would use the name that is on that permanent resident card as my obligation to complete the I-9 at that time was to review the documentation, the permanent resident card. It looked facially valid, and I would use the name that's on that. Now, if the employee comes to you and says, "Hey, I provided you with false documentation the first time. Here is my actual name, and here is my social security card that shows, who I am and that I'm authorized to work, and I want to use that." Now, I would say you need to get a new I-9 with that actual identity document. So if they tell you that they lied before and this is the correct name, then I'd get a new I-9 using that information. There's a good question about re-verification versus submitting a new e-verify case. Those things, to answer your question, you are correct. Those things are not the same. So re-verification and submitting a new e-verification not the same.
One question is asking about if an employee shows an employee authorization card. I'm presuming that means an EAD, an employment authorization document. Do we also need the social security card that goes along with it that says valid only with work authorization? Well, if someone showed the EAD, that suffices for identity and work authorization. So the social security card itself would not be necessary unless this is referring to E-Verify. Well, we thank everyone for attending. It's been a pleasure meeting today. And again, this will be on our YouTube channel, and we can also send it to attendees who registered. Thank you, and feel free to reach out if we can be of further help.
Really appreciate you guys attending, and hopefully this was helpful.